Hi, everyone. Carl Steinbeck here on this Tuesday afternoon, resuming coverage of the Dr. Gerhardt König trial, where he in Hawaii, there in Honolulu, is facing attempted murder charges. And that is for the attempted murder of his wife, Ariel. And this thing is going to be going to closing arguments here. I got my wires crossed on the start of this, so I wasn't able to cover the rebuttal witness. They had the detective back on for some brief testimony, and then the jury's been giving the instructions on the law that they're to follow in their deliberations. So we're about to start up here the closing arguments in a few minutes. So I noticed they had some lesser included instructions, lesser included charges, aggravated assault, different types of assault charges that are not as severe and serious as attempted murder. So we also did have him striking her so they could find him guilty of assault and aggravated assault using that rock, but not guilty of attempted murder. But I really think what the prosecution will focus on and should focus on to get an attempted murder conviction is the reasons why this whole thing was staged the way it was for him to get her alone on a steep edge of a cliff. Because if you look at what he was doing at the months prior to that, he was financially realizing the loss he would have if there was a divorce. A divorce a second time, he'd already had such a devastating loss of finances if with the first divorce, and then having another divorce, another kid's involved. He's the primary breadwinner of the two parents. And so I think the prosecution is really going to focus on he didn't go up there to beat her up. He went up there to accomplish the mission. What was the mission? The only mission that makes sense based on the way he was acting is that he wanted to end her life, because with an ended life, all that financial pain would go away. So anything short of a murder was not going to alleviate the financial ruin as he was seeing it coming down the pike. So that's why I think it really comes down to him also looking. They showed the files that he was opening of his past divorce, what he's paying for alimony, and then we saw him testify that, no, I like paying child support. I should say not alimony, but child support. No, I like paying child support. You know what? Nobody likes paying that. So, sidebar, so you're wanting to know why neither side called the alleged affair person Jeff Miller. I just think that he probably didn't want to get involved, number one. Number two, that wouldn't have prevented him from being subpoenaed, obviously. But I just think it was more of a side issue. And so I think that I wasn't expecting him to be called. You're going to get too much in the side drama. The prosecution got in what they wanted as far as the motive. The motive was he was fuming mad about his wife having an emotional attachment to somebody she was a coworker with, and it was ongoing. It was secretive behind his back, and he was going to do something about that. He was not going to tolerate it. He tried to have it cut off, but it wasn't working. It wasn't working. He wasn't satisfied. And because he wasn't satisfied, he didn't trust Ariel. And because he didn't trust Ariel, what are the options? The options are either down the pike, it's going to be divorce, and then he's going to be paying for another situation where he's going having to support two kids and maybe supporting her. So it's just not going to, in his mind, that's too much of a financial price to pay, and she didn't deserve it based on her not upholding her end of the marital vows. So he thought that this was the best option to go with, and he thought he could get away with it. Oh, it's a slip and fall case off of a cliff. Amy Daniels, do I think the prosecution was a little weak in their lack of pursuing in-depth questions of the doctor about the actions that happened on the hike? I feel like they should have drilled hard. I mean, the prosecutor could have gone in a lot more details not only with that doctor, but also with, there we go, with the doctor himself, Gerhardt. Oh, you're talking about Gerhardt. Okay. I agree with you on that.
The attorneys will now
Stand
have
by.
an opportunity to give you their closing arguments. Keep in mind, what they say is not evidence, and you're not bound by how they see or how they remember the evidence. You should consider their arguments to you, but again, you're not bound by how they see or remember the evidence. Mr. Garner, are you ready with the state's closing argument?
Yes, Your Honor.
Please.
And for the record, the state is reserving some time for rebuttal.
Understood. Thank you.
Joel Garner here, the prosecutor.
A motive, a beating, a confession. Ladies and gentlemen, beyond a reasonable doubt, the state has proven that on March 24th, 2025, Gerhardt König tried to kill his wife, Ariel. The state has proven beyond a reasonable doubt that Gerhardt König committed the offense of attempted murder in the second degree. There are two elements, as Judge read to you a couple minutes ago. Element number one, on or about March 24, 2025, that if in the city and county of Honolulu, the defendant intentionally engaged in conduct. Element number two, we'll get back to in a moment. But the conduct, starting with element one, what is the conduct? What did defendant do? First, he tried to push her. That's the first conduct the defendant did. The second, the syringe. He tried to inject her with an unknown substance. And third, the beating with the rock. That is the conduct that defendant engaged in intentionally. That is the conduct that we are here to talk about for the last several weeks and for today. The second element, that conduct, under the circumstances under which defendant believed them to be, was a substantial step in a course of conduct intended or known to be practically certain by the defendant to cause the death of Ariel König. So element number one, simple, it's conduct. Element number two defines what that conduct is, what it's meant to do. And the conduct in this case was meant to kill. The intent behind each one, plan A, the push, the intent was to kill. When plan A didn't work, the defendant moved on to plan B. Plan B, inject her with the syringe, knock her out, push her off the cliff. The intent behind plan B was to kill. Plan C, when the first two plans didn't work, beat her with the rock, knock her out, drag her over, or just simply kill her outright. The intent behind every single plan was to kill Ariel. Every plan, every backup plan ends in Ariel's death. The substantial step starts with the plan. The plan's in yellow because it's not a substantial step yet, it's just a plan. Next, the hike. Again, it's in yellow because he hasn't taken that last step. That last step to show he's committed to carrying out that plan, that shows he's committed to killing Ariel. The first time you get that is with the push. When the defendant takes his hands, tells Ariel, "I'm sick of this shit," and tries to push her back off the cliff. That is the first substantial step the defendant took. That didn't work. Ariel went to the ground. Ariel protected herself. The defendant took the next substantial step. He took that syringe out and he tried to inject her. But Ariel fought back. Ariel fought back, fighting for her life, knocks the syringe away, and then the defendant moves on to plan C, his third substantial step, where he takes that rock, Exhibit 2, this rock right here, the same rock that you've all held, he takes this rock and he beats her with it again and again and again and again. Those 3 steps are the substantial steps the defendant took to carry out his plan to kill Ariel König. Before we get any further, what is not a defense? The result of the defendant's conduct. The severity of Ariel's injuries, you'll hear many times trying to minimize them. That is not a defense. The law treats somebody the same, whether they're successful or not. The law treats you the same no matter how good you are at executing that plan, no matter how good you are at actually succeeding in killing somebody. The law treats you the same. As an example, somebody who tries to shoot somebody, who points a gun and tries to end a life, but misses, they've committed attempted murder the same way the defendant committed, in a similar way, in a similar idea as the way the defendant did it in this case. You cannot look only at the results to determine intent. You have to look at everything together. And when you look at everything, it shows one clear answer beyond a reasonable doubt, and that's that the defendant intended to kill her. Let's review how we got there.
Motive.
First, we have Ariel's testimony. She testified in 3 different areas. First, Ariel told you what happened on the Palipuka Trail on March 24th, 2025. She told you what happened when she went up the trail. She told you how she was afraid, how she was nervous about the heights. She told you how the defendant reacted. She told you what happened when she met up with the defendant later. That he pushed her, that she went to the ground, that he took the syringe, that she fought back, and that ultimately he took that rock, this same rock, and hit her in the head again and again. Then Ariel told you what happened leading up to that day. She told you about their marital issues. She told you about her messages with Jeffrey Miller. She told you all of that. Embarrassing as it may be, she put it all out there. And then Ariel told you about her treatment, her medical treatment, her recovery. She showed you the scars that she carries to this day. She showed you the scars on her head where she will never grow hair again. And everything that Ariel said is corroborated. These are the credibility factors. These are listed in your instructions that you should be considering for every witness who testified. And I'm not going to go through all of them right now, but there's a couple that are relevant for Ariel here. First, appearance, demeanor, intelligence, candor, frankness. Ariel testified in a straightforward, coherent manner. She testified clearly. There were no histrionics, barely any tears. It was straightforward. This happened, then this happened, then this happened. It was not over-dramatized. It was not over-exaggerated. It was straightforward and simple and coherent. She was open to cross-examination. When the answer was yes, she said, yes, sir. When the answer was no, she said, no, sir. And when she didn't know, she said she didn't know. But the last factor is the most important here. The extent to which Ariel's testimony is supported by other evidence. What this means, simply, is corroboration. What level of corroboration is there? There is a lot. Ariel is corroborated by the physical evidence, the scene and location, the rock, the blood evidence, the injuries, the medical supplies. Ariel is corroborated by the digital forensics. What was going on the defendant's computer corroborates what Ariel said. Ariel is corroborated by the other witnesses, by their sworn testimony, by Emil König. Ariel is corroborated by Amanda Morris. She's corroborated by Sarah Buxbaum. She's corroborated by HPD. And in the most important ways, she's even corroborated by what the defendant told Emil. You've seen the photos at the scene. Ariel's testimony is corroborated. There's the cliff. It's right there. There's the bloody, the blood pool in the bush where the defendant was on top of her, where the defendant was hitting her, the physical evidence of the scene, the blood, the crushed plants, the location of this so close to the cliff edge, all corroborates Ariel.
He's doing good.
The physical evidence, the rock, corroborates Ariel. You've held the rock, you've seen it, you know how much it weighs, you know how sharp it can be on the sides. You've seen the photos of Ariel's blood and Ariel's hair on that rock. The rock corroborates what Ariel said. The DNA evidence. The DNA evidence shows two things very clearly. One, every single sample that was positive for human blood had a likelihood ratio of over 1 trillion for Ariel König. Every single one. The blood on the rock, the blood on the samples from the trail, the blood all over defendant's shirt and shorts. Every single one had a likelihood ratio of over 1 trillion for Ariel. Reason and common sense tells you all of that blood is Ariel König's, not the defendant's. Second, Ariel König's DNA was on both sides of the rock. And think back to how Ariel demonstrated what she did. She held up her hand. She held up her hand trying to block the defendant. She suffered defensive injuries from it on her fingers, on her thumb, and that's how her DNA is on that rock.
Good eye contact.
Because she touched it. Her touch DNA is on the rock because she touched that rock to try and stop the defendant. The search warrant of defendant's work bag on Maui corroborates Ariel's statement. It shows clearly, conclusively, that defendant had actual possession. Not as some sort of theoretical, oh, he's a doctor, he can get this stuff. No, he had actual possession of syringes, he had actual possession of vials, he had actual possession of drugs that can kill. This isn't some, he could have gotten them, he had them. This corroborates Ariel's testimony. And more importantly, these drugs weren't stored in a controlled environment. They were stored in his home, where he had access. He could take them, didn't have to log them or anything, just remove them from his home and do whatever he wanted with them. This corroborates Ariel as well. Lastly, Ariel is corroborated by her injuries. The physical evidence of Ariel's injuries corroborates exactly what she said. Think of the injuries to the top of her head. The stellate laceration. Dr. Groskeen told you there was debris throughout the entire injury. There were rocks. The defendant swung this rock so hard that pieces of rock broke off into Ariel's scalp. There was dirt throughout the entire laceration.
It was rage.
The middle of Ariel's scalp, he described as macerated or crushed. It went all the way down to the bone. You've seen the photo of Ariel from the front. You've seen what's missing from her head. You've seen that there is a chunk of her scalp that is gone. It's right there in that photo. And you've seen that she didn't just have scalp injuries. She had injuries above her eye. She had injuries below her eye. She had injuries to her hand, not even to just her thumb. Her thumb was only where there was a break. But she had injuries to 3 of her fingers. Her thumb, her index, and her middle finger. Ariel's testimony is corroborated by the physical evidence in this case. Ariel's also corroborated by the digital forensics, the digital evidence. The digital evidence tells you what defendant was thinking, what he was thinking from December 2024 to March 2025. It shows you that, first of all, it confirms the motive. It confirms the strong motive defendant had to kill because he was looking up infidelity. He was looking up Ariel's financials. He was looking up his prior divorce. He was going into Ariel's hard drive to look up documents on her computer or from her computer about divorce. He even went to the point where he was buying a spy device to spy on Ariel. This shows what was going on in defendant's mind. It wasn't some simple research. It wasn't taxes. It wasn't self-help. It was obsession. It was an obsession with Ariel. It was an obsession with infidelity. It was an obsession with going over those financials, and it was a plan for divorce. The second thing that the digital forensic shows, most importantly, it shows defendant's familiarity with that hike. It shows you what the defendant looked at before deciding the Polypuka Trail is the hike that he should be taking Ariel on. It showed the defendant this picture right here. It showed that the defendant was only interested in difficult hikes. Easy hikes were not for him. The defendant wanted difficult hikes, steep trails, big drops, narrow trails. This is where the defendant wanted to take Ariel. This trail, about a foot wide, somewhere around there. One push is all it would take on this trail. Nothing for her to grab onto. One push, and it's a tragic accident. That is what the defendant was researching. He knew that this trail was not popular from his research. He knew that 99% of the people wouldn't be going on this trail.
Good point.
And he knew that this is where he could execute his plan. And he didn't share this with Ariel. He didn't share this website with her, so she could make that informed decision before she went on that hike with him. She had no idea what kind of trail she was getting into that day.
Good point.
Lastly, Ariel is corroborated by the other witnesses. Ariel is corroborated by Amanda Morris. Amanda Morris, the first person on the scene. Amanda told you the sequence of events. 3 things. First, she heard a woman's voice screaming, "Help, help me." And she gets up the trail because she thinks somebody's fallen off. She knows it's dangerous, she thinks somebody's fallen. And she sees the defendant over Ariel. Amanda sees the defendant over Ariel. She sees the defendant with this rock in his hand, and she sees the defendant hit her. And when she sees that, Ariel cries, "Help, he's trying to kill me." And Amanda sees how the defendant responds. How the defendant responds is nothing. He just looks at her. Ariel's also corroborated by Sarah Buxbaum, the second woman on the scene, the second hiker who intervened. Sarah came in behind Amanda. She saw the defendant standing over Ariel. She saw the defendant standing with that rock. And most importantly, Sarah looked the defendant in the eye. Sarah made eye contact with the defendant and told you how that made her feel. It made her feel unsettled. It made her feel so afraid for herself and her safety when she was looking at the defendant in the eye. It made Sarah feel so unsafe that she and Amanda went back down the trail before they called 911 because they realized this was a dangerous situation for them. They realized after looking in his eyes what could happen to them. And they took those steps after seeing what was in the defendant's eyes. After seeing that look, they took steps to protect themselves. Listen to Sarah's voice on that 911 call. It's Exhibit 3. You'll have it. Listen to her voice, and you can hear what she's thinking about. You can hear the worry in her voice. You can hear that she's afraid for her own safety after she's seen the defendant. It's all there. And you may hear argument today, or have maybe you thought to yourself, well, Amanda and Sarah only saw the end. The evidence shows that Amanda and Sarah didn't see the end of the incident. They caused the end of the incident. Because when they showed up, that is the only thing that stopped the defendant. Ariel screaming for help didn't stop the defendant. Ariel fighting back for her life didn't stop the defendant. The only thing that stopped the defendant, the only thing that was enough for him to stop, is 2 eyewitnesses coming up on the scene and seeing him beat her with that rock. The only thing that got him to stop was being caught red-handed. The responding officers, Corporal Wu, Corporal Chun, they corroborate Ariel as well. They showed you the hike. You saw the hike on their body cam. You saw their struggles with trying to get up the hike. They showed you the scene. Once more, right there in the foreground of this photo, that's where this happened. That's where the beating with the rock happened. And right there, just a couple feet away, that's where the defendant tried to push her. They showed you Ariel's condition. Ariel's condition immediately after the defendant did this. They showed you that. They showed you the closest thing to what the defendant last saw Ariel as. And they even caught it on their body cam.
That's
They
not
even caught
self-defense.
Ariel's condition as she states her name.
Ariel König, Gerhardt Birthday is March 24th, 1989.
He was striking
You
her in
heard
the
Ariel
head.
testify for hours,
The rock? No way.
but also you heard in this video her slurred voice, her heavy breathing, her condition after the defendant beat her with that rock. She was not okay. The manhunt corroborates Ariel as well. It took 3 different agencies, HPD, DLNR's DoCare, HFD, several different units from them, SED, SSD, a canine unit, the major events unit to search with drones. It took 2 drones, 1 helicopter, and after 8 hours, or almost 8 hours, they were still not able to find the defendant. And that tells you one incredibly important thing. The defendant did not want to be found.
Wasn't
The
a victim.
arrest corroborates Ariel just as much. Officers Nicola, Koki, and Borges approached Ariel in their vehicle. Officer Nicola testified he got within an arm's reach of of the defendant before he jumped out the car.
Objection, misstates his testimony.
He got within an arm's length or close to an arm's length before he got out that car and tried to apprehend the defendant. He identified himself as police. And how did the defendant respond? The defendant tried to flee into the woods. It took a total of 835 pounds of HPD officers to subdue the defendant. That's how much he was resisting.
Victims don't do
He knew
that.
they were police. They identified themselves as police. And as Officer Nicola testified, the defendant, in his attempt to get away, fell on his face, and then Officer Nicola fell on top of him. That's why you see the grass on the defendant's head. That's why you see the dirt on the left side of the defendant's face, because that's where he hit the ground. That's where he hit the ground while he was being arrested. And the defendant's own actions finally also corroborate what Ariel told you. Defendant's actions corroborate Ariel's testimony. First, he fled the scene. Second, he collected the evidence from the scene. He collected Ariel's phone. He collected Ariel's purse. And he collected those syringes. He took all those items from the scene and he disposed of them. Ariel's mom still tried to ping her phone, and it was up at the poly hours later, but they could never find it. And think back, where DoCare couldn't search. They couldn't search the bottom of the cliff. They couldn't get down that way. They searched the whole mountainside, couldn't find it. But the bottom of that cliff that's several hundred feet tall, that's where they couldn't search. Defendant confessed. Defendant called Emil just minutes after the incident and told Emil, I tried to kill Ariel, but she got away. And lastly, the defendant hid in the woods for almost 8 hours. These actions that the defendant took corroborate what Ariel told you. They make sense. That being said, the defendant in this case has testified. And you need to judge his testimony the exact same way that you judge anybody's. At the beginning of this trial, you heard a theme, some alliteration with a theme, unwilling or unfaithful, unwilling, untrue. But ladies and gentlemen, after listening to the defendant's testimony, you only need one word to summarize it. One word. Unbelievable. The defendant's story. She started an argument. The defendant's story is that somehow Ariel, on her birthday, on an unfamiliar hike next to a massive cliff, decided to start an argument. Does that make sense to you? No. Mm-hmm. Ariel decided somehow to start an argument about she said she wanted to go back and continue to work with Jeff Miller. She wants to travel with Jeff Miller. Does that make sense that Ariel would bring this up on that cliffside? No. It contradicts common sense. It even contradicts the defendant's own testimony where he told you they don't talk about this outside of counseling. The defendant told you that, and that's what worked for them. And somehow Ariel's bringing it up, ruining her birthday on a hike. Ladies and gentlemen, it's unbelievable. The next part, the defendant's story. She pushed me. The defendant says he felt a hard push from behind, that he was looking out over the cliff. He barely holds himself on. He turns around, and Ariel's already 5 to 10 feet away. Ladies and gentlemen, unbelievable. If Ariel was trying to push him off that cliff, she wouldn't be that far away. She would have been right behind him, trying to push him again. Defendant's story, she pulled me down on top of her. Think about how that makes sense. Defendant's story is that then he approached Ariel. That he grabbed her arms. And Ariel somehow responded by pulling him down on top of her and not letting him go. Defendant's bigger than her. Defendant's stronger than her. Ask yourself, what person would hold a bigger, stronger person on top of them as an act of aggression? It doesn't make sense. It's unbelievable. Defendant's story, she hit me first.
Too convenient.
Somehow while Ariel's sitting down, or while Ariel's underneath him, while he's in the position of power, while he's on top of her, the story is that Ariel held him down so he couldn't escape, grabbed his genitals, wrapped her legs around him, and then she picks up a rock and hits him in the face. And as the defendant told you, he said, she hit me one time really good, and that she keeps swinging. The same rock that the defendant used to beat Ariel? Really? The same rock that defendant has told you he only used 2 times, that he only hit her twice with. Ladies and gentlemen, it's unbelievable. The same rock, no. You can tell it's different injuries. This is the photo of the defendant immediately after his arrest. This is the photo of the defendant almost 8 hours after the incident up on the trail, after the defendant tried to kill Ariel.
It's not from Ariel. Russ from the
Yes.
cops.
There's a small dark spot on his cheek. Is it a bruise? Is it dirt? I don't know. This is Ariel. The idea that this same rock caused these different injuries is unbelievable, ladies and gentlemen. The idea that Ariel could hit him really good,
Good point.
and that's it, it's unbelievable. This is the defendant at the hospital that night, and this is Ariel at the hospital on the same day. Again, minor bruise, major laceration. The idea that these injuries were caused by the same rock, completely unbelievable. You can only see that by looking at the next day. Look at the defendant 1 day later. There's nothing. There's no more. Ariel's got her head wrapped up. She's still got these injuries on her eye. The defendant's story is unbelievable. And lastly, the defendant told you that he wanted to turn himself in, that that's what he was doing when he left the trail. Sunset was coming soon. The sun was getting low. But instead of doing the logical thing and walking down the trail where he knew the police would be, the defendant decides he has to come out of the forest onto the road. The defendant doesn't go back to the trailhead. He doesn't put his SIM card back in his phone. He doesn't turn his phone on because he's not trying to surrender himself. He's not trying to turn himself in. He's trying to escape. And that's why he ran when the police apprehended him. That's why he resisted. The defendant's story, unbelievable. The defendant's story, unlike Ariel's, where Ariel is corroborated, the defendant's story is filled with contradictions. Defendant is contradicted by Amanda and Sarah. Somehow, Ariel finally let go of his private parts, and then he just stands there and looks. He's not on the ground writhing in pain. Does that make sense? He says that she held on so hard that he couldn't escape. Does it make sense that afterwards he would just stand there and stare? No. Defendant is contradicted by the physical evidence. He's contradicted by the fact that there's no blood of his up there. There's no evidence of injuries that support what defendant says happened. He's even contradicted by his own hired doctor. Yeah. The defendant told you he hit her twice, no more. But even his own doctor said 2 to 3 hits to the scalp, hits to the face, hits to the fingers. So even the defendant's own witness shows that he hit her more than twice. He hit her, add them all up, 4, 5, 6, could be any of those times. He hit her again and again and again and again. And he only told you 2 times. Ladies and gentlemen, it's unbelievable. He told you he removed his SIM card with a paperclip. Well, state 72 through states 86, that's all the photos. That's all the contents of defendant's backpack. Where is that paperclip? He could have just as easily used that syringe. Open his SIM card, dispose of the syringe. Hiding evidence 2 ways at once. The substantial step again. He made the plan. He made the plan to go hiking that day. He didn't share with Ariel what hike they were going on. He didn't share the details of that hike with Ariel. He didn't share the dangers of that hike with Ariel because his plan was to push her off that cliff. So they start the hike, and Ariel deviates from the plan. Ariel doesn't go up to that section from the photo, the super narrow section with no trees. Ariel doesn't want to go up there. So the defendant improvises. The defendant picks a different cliff. The defendant sees his last chance when they take this selfie, his last chance before they get to that lower part of the trail, and he takes it. He takes that chance to try and push Ariel off. He takes that chance. He makes that substantial step. And plan A, the push, doesn't work. Ariel falls to the ground. He can't push her off anymore. So he takes that next step. He pulls out the syringe. Plan B. And he tries to stab her with it. Plan C, when that doesn't work, he takes that rock and he hits her well over 2 times. He hits her again. He hits her again. It doesn't matter that she's blocking. It doesn't matter that she's screaming. The only thing that gets him to stop is these 2 women who walk up. That's it.
That's real damning.
You have gotten instructions about self-defense. It should be clear. The defendant was using deadly force in this case. This rock is known to the defendant to cause death or serious bodily injury. You don't need to be a doctor, although he is. And he's actually treated patients who've had rocks fall on them. So the defendant is well aware of the damage that he was doing. He's more than aware because it was his intent. It was his intent to cause that damage. It was his intent to cause death. So yes, it is clear the defendant was using deadly force. And because of that, self-defense doesn't apply. Or self-defense does apply, but defendant cannot claim it because he was the initial aggressor. He was the one who started the physical altercation. He was the one who used deadly force. And lastly, he had a duty to retreat. When using deadly force, before you use that deadly force, the law states you have a duty to retreat. And the defendant didn't do that.
Incomplete statement on the law. Objection overruled. Ladies and gentlemen, the court instructed you on what the applicable law is. You need to follow the court's instructions as read out to you and as it's provided in the jury instructions that you have.
That's a bad move, defense counsel.
The defendant did not follow the law. The defendant attacked her. Self-defense is not applicable. The state has disproven it beyond reasonable doubt because the defendant was the initial aggressor. The defendant was the first one to use force. Based on these facts, self-defense is not applicable. Next, you're given instruction on extreme mental or emotional disturbance. This is a long instruction. We'll keep it simple. There's no evidence that the defendant was acting under extreme mental or emotional disturbance when he tried to kill Ariel. Don't be confused by his testimony. He did say he was under severe emotional distress, but he said that after he tried to kill Ariel. He said he was under severe emotional distress after he started to think about how this would affect his job, how this would affect his life. He was under severe emotional distress after he began to think about the consequences of his actions and how his actions would affect himself. That's what that is. The defendant was not under extreme mental or emotional disturbance when he tried to kill her. He only became that way when he began to think about the consequences. And the second part of that instruction states that the defendant's self-control, the defendant's logical thinking is important here. It shows the defendant, when plan A didn't work, he moved to plan B. When plan B didn't work, he moved to plan C. And when he got caught, he fled the scene, he hid the evidence, and he hid himself. That shows the defendant was using logical thinking. The defendant was solving problems as they came. He was not acting under extreme mental or emotional disturbance. Okay. You got a list of other included offenses. You got a list of a bunch of assault charges that are included in the attempted murder and second degree charge. When you think about those, just think one thing. He did more. This is what he did. Assault in the third degree, causing bodily injury. Ladies and gentlemen, that means physical pain. He did more. He did more than cause physical pain to Ariel. Assault in the second degree. He did more. Yes, the defendant caused a major laceration to Ariel's head, or severe laceration. The defendant caused a bone fracture to Ariel's thumb. Yes, he did those things, but he did more. But he did more because he was trying to kill her. Attempted assault in the first degree, same thing. Defendant took actions that he knew would cause a substantial risk of death. Yes, but he did more. Because the evidence all shows that the defendant wasn't intending to do an assault. The defendant was intending to kill.
Yep, that's what it looks like.
All right. 3 things: motive, a beating, and a confession. You've seen through this trial the defendant's motive. He was upset. He was angry. Wherever he turned, Ariel wasn't being punished. First, he talks to Ariel's best friend, tries to air the dirty laundry. But the best friend stays on Ariel's side. Deanna stays on Ariel's side. She's not punished. Then he emails Andrea Miller. giving this other woman Ariel's personal contact information, her cell number, her personal email. But Andrea Miller never responds. Ariel's not punished. And then he goes to counseling. They go to marriage counseling. And instead of focusing on the affair, what do they focus on? These intimacy issues, these issues that Ariel testified about, these issues that were defendant's fault. Everything the defendant tried to do made sure Ariel was never punished. So he did it himself. Every response defendant had to this emotional affair showed the defendant's need to control Ariel. He wanted to control where she lived. He wanted to separate this woman from her 18-month-old child. That was his response. His response to finding out was, you should move out. He wanted to control her job. He wanted her to quit. He wanted her to be dependent on him. Because once Ariel quit her job, it's much harder to divorce. She has no more income. She can't go find another remote worker, nuclear engineer job. The defendant knew how much a divorce would cost. He was looking at his own documents, his own records from his prior divorce. He was looking at his own records that showed how much he paid in his prior divorce, because that's what he was thinking about. He was doing that math.
That's the motive.
He was doing that math on what it would cost to divorce Ariel, what he would give up. And he just couldn't stop thinking about it. He couldn't stop thinking about this emotional affair that he's built up in his head. And because he couldn't stop thinking about it, he made a plan. He made his plan to kill Ariel.
Rage and
The
obsession.
beating. Plan C, the third substantial step, the one that's the most visible, the one where she got these injuries. The defendant took the rock. He picked it up. He swung at Ariel again and again and again and again and again. That many swings shows that the intent was not just to hurt. It was not just to defend. The intent was to end her life. That's what the number of swings tells you in this case. And Ariel's only relief, the only thing that stopped him, was the defendant being caught in the act. It was the intervention of Amanda Morris and Sarah Bucksbaum. That's it. So we end with the confession. 10:42 a.m., just a couple minutes after this happened, the defendant calls Emil. It's a video call, not a phone call. So Emil could see what the defendant was saying. He could see the defendant's face. He could see the defendant's mouth moving. There's no gray area with this confession. As Emil testified, he has no doubt about what the defendant told him. There's no phantom gust of wind that came up. There's nothing like that.
I do.
The defendant confessed to Emil. He told Emil that he tried to kill Ariel. He told Emil why. He told Emil that Ariel got away. He told Emil that Ariel was having an affair. That doesn't sound like a goodbye suicide message, does it? He told Emil that he was at the end of this rope. And think back to the last thing that the defendant told Ariel before he tried to kill her. He told Ariel, I'm sick of this shit. That's corroborated that he's at the end of his rope. Same idea. What didn't he tell the defendant? What didn't the defendant tell Emil? Nothing about self-defense. Nothing about Ariel attacking him. Nothing about what he testified to you. Is that reasonable? Does that make sense? No. 10:42 a.m., the defendant FaceTime video calls Emil. He confesses. And Emil's next step, after being put in that situation, after being put in a situation as a 19-year-old that he had no want to be part of, Emil does what he does. He goes and tells his grandparents. He goes and tells them what the defendant said. And Judith Mast, ends up texting the defendant, 11:33. She texts the defendant, is Ari okay? She asks the defendant about her daughter, and the defendant says nothing. He doesn't respond. But what he does do shows his intent. What he does do, he calls Emil again, and he asks him, "Did you tell anybody?" That shows the guilty conscience of the defendant. That shows that the defendant was not acting in self-defense. That shows the defendant was thinking about what his actions would do to himself. He was thinking about himself. He wasn't thinking about Ariel. He wasn't thinking about her condition. It was only himself. So, ladies and gentlemen, there's one verdict and only one verdict that does these things. There's one verdict that holds the defendant accountable for what he intended to do, for what he tried to do to Ariel. There's one verdict that's supported by the physical evidence, the digital evidence, the corroborated testimony of witnesses, and the defendant's own confession. There's only one verdict that's corroborated that makes sense with all of that. There's only one verdict that the evidence and justice demands. And that verdict is that you find the defendant guilty as charged of attempted murder in the second degree. Thank you.
Great job. This prosecutor looks so young, it's like hard to take him serious, of course, but he nailed it. Excellent delivery, excellent eye contact, hit all the key points, all the minute details that supported the motive to kill. So I give him an A. He also had to
Thank you, Mr. Gardner. So, ladies and
withstand
gentlemen,
two
super
objections,
second morning
ridiculous
recess.
objections.
Ms. McCallum can get you, I'll just say 11:10. We'll reconfigure the courtroom during the recess. We will come back. Defendant will have the opportunity to present.
Okay, they got about
All right.
almost a 10-minute break here. So yeah, he was super organized as no waste of time, Moto 88. I agree with you on that. So he did amazingly well considering how young he is. I'm telling you, most prosecutors that young, they're going to be completely fixated on reading a script, and this guy did not do that at all. He totally was going a little bit off the slides here and there, but he knew the case. He had perfect delivery in front of the jury with using the slides to bolster the points he was making. And so I don't know that defense counsel is going to be that good. I just think that the way this methodical takedown of and dismantling of the defendant, I think, is going to carry the day. So there's some folks that think that prosecution hasn't done their job, but that happens in every case, folks. I just am telling you from my experience, I see the jury convicting this doctor, and I think the most sensible outcome is him to be convicted of the attempted murder, because, like I say, the motive was to end her life. There was no other thing short of that. Well, hey, I'm just going to go beat her up. I'm mad at her. I'm mad at her because she's had this relationship with this coworker, and I'm just hating on her for that. And I want payback. No, what he was trying to do was set up himself up for a future life without the financial burden, the horrific financial burden. He was not wanting to pay child support and lose the assets they've acquired. So that's what the prosecutor hit on, and that's why he was going through, looking and ruminating all those different financial records in the months leading up to this attempted murder. And all he had to do was get her over the cliff. If he would have gotten over the cliff, there would have been no defense. No one was in his mind going to be able to see this at all. And if he would have been able to successfully push her off before those two witnesses showed up, then it would have been successful. No one would have challenged it, and they would have never looked at this thing other than, hey, here's a doctor talking about his wife that slipped and fell and went off the cliff, and they were trying to do a selfie off the cliff, and they probably would have not thought much more of it. But everything this guy did leading up to the day of the murder, attempted murder, and also the way he acted minutes after this happened. In fact, when you look at how he acted during this assault, nothing he did is consistent with a guy that loves his wife It's everything he did is consistent with a guy that's trying to get away with something, and then when he doesn't succeed because these witnesses show up and intervene in his efforts to kill her, then he's got to go run and hide. I mean, his wife is bleeding with blood all over her face, and he's going to go run. He's not going to call 911. Really, she had that amount of control over him. Please. So I think that in this Dr. Gerhardt's mind, I think he thinks he did well on the witness stand. He's believing everything his lawyers telling him. That's what happens with these guys. Clients just believe no matter how ridiculous it is, their defense theory, their story on what happened. It's just they think they're going to get away with it. So I'm sure these defense attorneys never told them that, hey, you know what, your story doesn't make any sense. Nobody's going to think your claim of self-defense is going to fly. Do you realize you're going down? So I don't think they did anything to cut a deal. I think they charged a big fee, and because of that, they're not going to tell him, hey, look, we think you ought to cut a deal. This guy's not going to cut a deal. He's going to stick with his story that, hey, I was wrongfully convicted. So that's my prediction. It's going to take only a few hours for them to convict him. And so we have, let's see, we have this break, and then we're going to get started back up for the defense closing. And then keep in mind there's a rebuttal option that the prosecutor will have. So I'm thinking that the rebuttal hopefully will be done before lunch, and all the arguments hopefully will be done before lunch. And just like in the Charlie Adelson case, Rashbaum, he started like about noon, and he went to like 1:30 or something like that, 1:40, and it was I thought that was a bad move because the jury was starving. They tuned him out. They had probably hunger pains like John and I were having there in the courtroom. So anyway, yeah, we do have a confession as well. I mean, you have to believe email the son, right? But I think the son came across as credible. And when you compare his story to what his dad said, he says, no, that he got that wrong. He got that wrong about, I just try to push her off the cliff. So I don't believe that. And I don't believe the jury's going to believe that for a second. Everything he did, it just oozes guilt. Please don't use all caps. It strains my eyes, and I don't even want to have to read something that's all caps. So please refrain from that. Thank you. D 1905, 1955. You're saying Gerhardt did well on the cross because the prosecutor basically asked him yes, no questions. You should have let him tell his story. No, you want to have more controlling of a witness than that, especially defendant on a serious case like this. I just think he should have gone into more details on what happened there on the trail. I was surprised he just sort of like walked away from that. But nevertheless, he did good enough, and the defendant sunk himself. Defendant helped remove reasonable doubt. There's no reasonable doubt here. The way he came across and what he said happened, it's just not credible, any of it. His demeanor was absolutely terrible. It was atrocious. So I think we'll have a verdict today. I think that we do have one person with like pink, purplish hair that could be on the jury. Remains to be seen. Hopefully there won't be some outlier. I don't think it will be. The jury composition is 10 females and 6 males. So everyone is a local there, Hawaiian descent, native, and there's only one Caucasian on the jury. I don't think that makes a difference at all. I saw there's some talk there about how these guys aren't local to the area and will they be treated differently. I don't think any of that is the case. And so I think that has no bearing. I think the evidence speaks for itself. So if anybody's going to say, well, there's no if this one white male doesn't make it on the jury, then he's not going to get a fair trial. I don't believe that at all. I believe wherever I've been across America, I've been in the military, I've done many court martials. I don't believe people look through that kind of lens of being, hey, you're different than me, I'm going to judge you more harshly. So I've never found that to be the case, and I don't buy for a second that would be the case in Hawaii. So they're going to go by the evidence here, and I also don't believe there's going to be any kind of like class revenge where they're going to go find him guilty on a weak charge because of the fact that he's got money and that somebody on the jury doesn't. So I think people take their obligations seriously, and these are serious accusations. So I think that the jury is going to be doing the right thing here. So there's no hesitation. Here the jury's judge is coming back here. Stand by. Getting started back up here again. Yeah, I think they're going to be following the law, base everything on the evidence and following the law, applying the law to the evidence presented. What's credible, what isn't. So we're going a little bit beyond the 9-minute break here. Yeah, I mean, the FaceTime confession, that was an excited utterance of him. I don't think he was intending to kill himself. I think it was all emotional manipulation. We're almost there now, getting ready. Let's see what the defense does. Is this guy going to come across angry, this defense counsel? Is he going to have any slides? Is he going to be reading from his...
373, President called the lawful counsel of record. Jury is absent from the courtroom. Counsel, you want to see that Mr. Garner, you wanted to take up objections to the defendant's proposed defense.
Yes, Your Honor. The first is on slide number 14 on page 5 of the printout that defense counsel handed to both of us. It's a slide that says examples of deceptive behavior. I do believe this is impermissible argument that is essentially stating that Ariel has been deceptive in the past. It's an argument that is trying to make a 404 argument that says that she is deceptive now. That is the one reason under HRE 404 that you cannot use prior bad act evidence for. It is explicitly stated that you are not allowed to use prior bad act evidence to show conformity therewith. And that's exactly what this slide is attempting to do. So we strenuously object to introducing this, using this slide, using this argument that is against the rules of evidence. It's asking the jury to consider something evidence for an inadmissible purpose. So I do believe that's not appropriate. And that's the first objection.
We'll start with Siriano. Mr. Okage.
Your Honor, obviously her credibility is at issue, and there's been multiple examples in this case that has come up in the evidence about deceptive behavior, and it is critical, obviously, that we be able to point that out. So I've never heard of, we can't point out in closing how a complainant has been deceptive or dishonest. I mean, he just spent half an hour saying how Gerhardt was dishonest. So obviously that's fair game in any closing argument.
The issue is not commenting on the evidence. It's inviting the jury to not follow the law. That's the issue here. They are allowed to comment on the evidence that was introduced at trial, and I understand that. But what this is asking is not that. It's asking the jury to consider this evidence as, again, under the only improper purpose under 404B, conformity.
404B's.
These objections overruled. The defendant will be allowed to argue the complainant wins his credibility. It might be inadmissible under 404 with no exception of 404B. But there is the avenue that is state's ability to have found credibility and specificness of the conduct in those 6 weights of the state's objections of it.
The other objection from the state is somewhat throughout the defendant's proposed closing argument. There appears to be snippets of transcripts, and they appear to have been, some of them highlighted, some of them not. As the court and everybody here is well aware, the jury will not have transcripts available when they go into deliberations. They won't, and these transcripts are purported to be of the testimony during the trial. So they're not transcripts that were identified as exhibits and introduced into the trial. They're transcripts of the testimony of the trial. Everyone's aware the first question the jury always asks after going to deliberations is, can we have a transcript of the witness's testimony? And the answer is always, transcripts are not available. So it's not fair to the jury. It's to put these essentially unmarked exhibits into the PowerPoint. It does give undue weight to what that is, especially consider the jury is instructed to remember the evidence on their own rather than what the court reporter may have written, that it essentially gets around that instruction that the court.
I think the judge will deny this argument.
It puts undue weight on only these portions that the defense
Let him
wants to
present it.
put weight on. So I do believe it's not appropriate for transcripts to be referenced, trial testimony transcripts to be referenced in closing argument.
Can we drill down on that a little bit more, Mr. Garner? The real objection is the form in which they're displayed. Because if it wasn't question and answer, and it was just not even the paraphrasing, if it was just the verbatim testimony without the Q&A descriptions, that would not be objectionable.
That's correct. And that's why putting it in, this format with the new Courier font, when it's clearly a transcript written by somebody else, gives it undue weight. It takes away that.
Sorry, it's not the font. Only we know it's Courier font, but it's the format of the Q&A.
Yes, that's the main reason.
Okay, Mr. Otake.
Your Honor, I've done this in many trials. It's pretty commonplace. I've done it in civil trials. I've done it in criminal trials. We took the time and money to order the dailies, and it's what was said in court. It's the best evidence of what was said. And I'm just, whether it's in that format or another format, it's the same substance. There's nothing improper about doing this. I've done it many times in many courts. They have the option to order the transcripts and use their government resources to pay for it. They chose not to. And so this is what was said in court. And I'm not taking it out of context. I'm not going to argue it inappropriately. I'm not going to, it's just what was said. I don't know what font it's in or what, it is what was said. And we chose to order it and pay for it. And
I think judge will allow it.
I'm not
It's
aware
not
of
a
any
big
rule
deal.
that says we can't do this. So I'm asking that the objection be overruled and get on with closing.
I think he's accurate that he's done it before. It's sort of rare, but
Anything else you want to add?
No.
using a transcript in part of your argument, he ordered a portion of it. It's fair game. I think it's fair to allow it. Judge hasn't seen it often because he's also wondering, what should I do here? What's the right thing?
The slides with the transcripts, and they are in fact transcripts, there's no dispute about that, are not, they're the actual transcripts as
They're-
represented by counsel. It's not a misrepresentation of what was said. It's not even a paraphrasing of it.
How's that prejudicial
I'm
or improper?
comfortable about the form. At this point in time, I'll overrule the objection and allow the parties to proceed.
Thank you.
Good.
What has been provided to court?
Don't create an appellate issue.
Record to document the state's objections. It will be court's exhibit 1 for trial.
And Your Honor, I did show the state some demonstratives. I would like I don't believe they have an objection, but it's gonna be facing away from you, so I'll show it to you now.
Please.
This is the first one. Accurately describes page 2 of the instructions.
Okay.
And then,
Oh, shoot. All right.
That's a good job for the defense to
this is
have
the second one.
blown up diagrams.
Please, order no objections.
To these two demonstrative aids, no objections.
Anything else we should take up before the jury returns?
No, Your Honor.
Nothing from the state. Actually,
I don't know if they're generic or using from other trials.
approach really quick. Sorry. On the record, it's fine.
Off record?
On record.
Okay, sure.
All right, they're having a sidebar here. So jury's not in the room. They're back in the jury deliberation room, waiting to come on out. They're not deliberating, but that's where they hang out. Patricia, you think the judge seems fair, but he's been way too lenient with the defense, keeping out things that were germane, in my opinion. Yeah, there's one part I thought that he should have allowed in, but I'm not so concerned about it now. The prosecution got enough evidence where they have a solid case that's been presented in front of the jury. After the prosecution did their closing, as defense attorney, I want to do mine as soon as possible thereafter, not let it marinate in the minds of the jurors. So these kind of delays here, I'd be like wanting to move it ahead. Now, granted, there was a prosecution objection, but let's get moving on here. As a judge, you also want to get this to the jury before they go on lunch break. Because if there's an argument that needs to be made after lunch break, then they're going to have that extra time built in before they're allowed to deliberate. So not sure what the camera guy is doing here. Oh yeah, normally that's true. I'm forgetting that John told me that the jurors walk past them. So maybe they're not in the jury deliberation room. So this is such a tiny courtroom that might be an exception here. Okay, well, someone's case says a case is boring. Well, then I guess you don't need to follow it. Doing a poll, I've never done a poll. I would have to do that separately. The prosecution did have a rebuttal witness, the detective. And that was it. Defense didn't have any rebuttal after that. Yeah, as far as a poll goes, I mean, I'm not really concerned what the percentage is. The bottom line is the jury's going to find him guilty.
All jurors are back in the court. Ladies and gentlemen, thank you very much for your patience. Before we hear from Ms. Rotake, the argument that state made about justice requiring a particular verdict that Mr. Garner made right before we ended is stricken from the record. You are to return a verdict based on the evidence that's presented, or the lack of evidence, or reasonable inferences therefrom, as well as the court's instruction on the matter. Mr. Osaka, are you ready to present defendant's closing argument?
I am. Thank you, Your Honor.
Please.
Good morning, ladies and gentlemen. I want to begin by thanking you all for your time and dedication to this case. Most people serve on juries, couple, 2-3 days. You guys have been here for close to a month now, and I want to just express heartfelt thanks for that. It was your time and doing that made sure that Gerhardt got a fair trial. That's what this was about, and we appreciate your time tremendously. You know, we're at the end of the trial here, but I want to actually circle back to the very beginning. The very beginning, jury selection, and remind you guys about that. Multiple days, started off with 200-something jurors, whittled it down, excuse after excuse. People couldn't be here, couldn't be fair, couldn't set aside what they heard, weren't willing to give him a fair shake. And we whittled it down to less and less and less, and we ended up with the 16 of you here. And it wasn't by accident. It wasn't by accident. It's because we saw in you what we were looking for. Jurors that would wait until you heard everything. Jurors that weren't going to convict somebody based off of media reports. Jurors that weren't going to just look at one side of things. Jurors who had logic, reason, and common sense. And most importantly, jurors who had integrity to follow the law on reasonable doubt.
Objection, move to strike. None of this is evidence. This is statement. Please continue. I'd like to move to strike the entire closing argument up to this point.
That's strange.
Sustain the objection. Mr. Otake, please continue.
We went through that process. You guys promised us you would do certain things, and we knew that you would. Now, I'm going to walk you through the evidence and the law today, and it'll be clear that there's reasonable doubt all over this case. All over this case. Before I do, he wants to, whole unwilling, unfaithful, unwilling, untrue. We talked about that. He wants to say unbelievable. I'll add another unword. Undeterred. They're undeterred by the evidence. It doesn't matter what it shows. They're going to spin it in their favor. They came up with a theory and they went to search for facts to support it. They didn't look at the evidence and say, what's the theory that points that out? They came up with a theory and they tried to find any fact they could to fit it. They were undeterred. Undeterred by the DNA. The DNA shows, and I'm going to go through it, she's holding the rock. She's a trillion level DNA on the unstained side. Undeterred. Oh, must be because when she was blocking. Undeterred. The computer, I have to call Inuma again to say that sometimes the computer accesses these files. Undeterred. Still shows that he's looking at this credit card statement from 2018 to show that he has a financial motive, that it's cheaper to kill her than divorce her. Undeterred. Undeterred by the fact the eyewitness picks the wrong person out of the photo lineup. And still, she stared at him, looked into his cold, dark eyes, saw him very clearly, picks out the wrong person. Undeterred. Yeah. Undeterred by the bruise on his face. Oh, maybe it's dirt. Maybe it's dirt. Evidence should lead to theories. You don't come up with a theory and then search for evidence to spin it to fit your theory. That's what happened in this case. Ladies and gentlemen, I'm going to go through just some of the law initially, and then we're going to come back, go through all the evidence, and then I'm going to come back on some other parts of the law. So I want to start off first by reminding you, as you know, you took an oath, right? You told us that you would give your word that you would follow the law. You'd follow the law, and we know that you will. I want to start, you can follow along in your instructions if you want. I'm just going to start on page 2. Page 2. I talked to you at the beginning about these 3 principles of justice and fairness that keep our system safe for all of us. Anytime the government waves its accusatory finger at anyone, these principles kick in, and it's a safeguard. It's a safeguard, and that's summarized on page 2. You must presume the defendant is innocent of the charge against him. This presumption remains with the defendant throughout the trial of the case unless and until the prosecution proves the defendant guilty beyond a reasonable doubt. The presumption of innocence is not a mere slogan.
Not a mere slogan, but an essential part of the law that is binding upon you. It's binding on you. It places upon the prosecution the duty of proving every element, material element of the offense charge against the defendant beyond a reasonable doubt. Now, I'm a visual learner. I had this chart earlier to help you guys understand how that works. We talked about how the presumption of innocence, you don't start in the middle. You don't start in the middle. It requires that you start here. You start here. It requires that.
Not as angry right now, but
And then there's a gap. And it's a proof gap.
he's coming
This
across
has to be
angry.
filled with proof beyond a reasonable doubt before you even step this way. Before you even step this way. If there's no proof beyond a reasonable doubt, you don't move. You don't move. And let's look what a reasonable doubt is. You must not find a defendant guilty upon mere suspicion or about evidence which only shows that the defendant is probably guilty. Probably guilty is not good enough under the law that you took an oath to uphold. What the law requires, ladies and gentlemen, what is required by law before the defendant can be found guilty is not suspicions, not probabilities, but proof. And think about that word. It's a strong word. We don't pay enough attention to that word. Proof. That's a powerful word. Proof of the defendant's guilt beyond a reasonable doubt. That's the law. Probably not enough. That's the law. Again, visual learner, I have a chart to help you with this.
That's not a good chart. That's meaningless.
This chart summarizes
Weak.
page 2 in a more simple way.
This is a good one.
State's burden, it's their burden, right? We talked about they brought the charge. Make no mistake, this is not König versus Gerhardt König. This is the state of Hawaii versus Gerhardt König with their resources, the police force, their computer experts, their everybody. Their burden, state of Hawaii versus him. This is their burden. If they only provide, obviously 100% you think is not guilty, not guilty. Probably not guilty, not guilty. Possibly not guilty, not guilty. Maybe not guilty, not guilty. Maybe guilty, not guilty. If you're like, maybe, maybe not. If you're left thinking, I don't really know what exactly happened. Maybe, maybe not. If you're here, not guilty. Possibly guilty, probably guilty, not guilty. That's how high the burden is. It's a safeguard against convicting innocent people. This is what you took an oath to uphold. I'm going to circle back to this, but this is what you told us you would apply. Now, I'm going to go through more of the law later, but just very quickly, the law on attempted murder, the elements are on page 14. Page 14. Before we go through the evidence, page 14. Second paragraph. A person commits the offense of attempted murder in the second degree if he intentionally engages in conduct which, under the circumstances as he believes them to be, is a substantial step in a course of conduct intended or known to cause the death of another person. That his intentions was to kill her. That was his intentions all along. That's what they have to show. It goes down, paragraph 1, the elements. The defendant intentionally engaged in conduct. And 2, the conduct under the circumstances as the defendant believed them to be was a substantial step in the course of conduct intended or known to be practically certain by the defendant to cause the death of König. That's what they have to prove, more than maybe, more than possibly, more than probably. That his intention and his knowledge was practically certain he was going to kill her. That's their burden.
He's sort of shouting. Not a good look.
We'll come back to this. There is an instruction on self-defense. I'm going to talk about that at the end after we go through the evidence. They are the included offenses. I'll walk you through those as well. But let's now look at the evidence, and it'll be clear there is just massive amounts of reasonable doubt. So the first thing, one second here. This issue about, was this planned? Okay. Was this planned? This big plan, he just went through this motive that Gerhardt König, you got to know him, that he came up with this plan in late December that it was going to be cheaper to kill her than divorce her. What's his plan? Let's look at the evidence. Is there a reasonable doubt about that? Let's walk you through that. First of all, she brought up the idea of going on a trip to Oahu. That was her idea. Why would that be the plan? If you're planning on killing somebody, you're an anesthesiologist, you have access to, as they fault him for being a doctor, I'm going to get into that a little later, having these things at home that he uses to save people's lives, that your plan is, let me not stay on Maui where there's probably 800,000 less people and more secluded areas. Let me sneak syringes through TSA onto an airplane, come to the busiest island there is in Hawaii, 1 million people, go to a place, a trail, a parking lot I've never been to, that I'm not familiar with, and in broad daylight, 4 minutes from a very busy parking lot, I want to try and kill her. That's the plan. That makes absolutely no sense. Logic, reason, common sense. Why would you do that? The life insurance issue. Well, this is the busy parking lot. So I apologize. You saw this in, this was the plan to come here. With all these cars, all these people, he says 99% don't hike or whatever. He didn't know that. He put in here, this is the plan, according to them, that he's going to come to this unknown place with all these people, all these cars, and try to kill his wife instead of just doing it on Maui. That's the plan, according to them. The life insurance issue. Now, this shows two things. I mean, we're going to get into later about how he told her about it that morning, and she learned that morning if something happened to him, she would get $1.5 million. But it's relevant in another way. If in December and January and February, you're planning to kill your wife, why are you going through the process of obtaining $1.5 million on your life for her? That's not the sign of somebody plotting to kill somebody. That's a sign of somebody trying to work on, okay, look, we got to figure this out for our kids, and if something happens, there's, he's not planning to kill her. Now, the birthday card. He writes this morning. It's the only time she got emotional because she knows it was genuine. And I'm going to talk about that more later. He writes this. There isn't an obstacle in this world too hard for me to fight through for you. I would take on anything just to see your smile. You're one of the kindest, most giving and selfless people I know. Putting others before yourself. So much love. You're the heart of our family, fun, fearless, and a terrific mom. The kids and I hit the jackpot with you. He meant that. You don't write a letter like this because if you're planning to kill somebody 2 hours later.
To look innocent, it does.
There was no plan.
Does.
There was no plan. The Fed reservation. He made a reservation to go to dinner that night. He's not planning on killing anybody. There was no plan. This is from that day. They're having a great trip. They had gone through some rough times, but they were making some progress, in part because they weren't really talking about it. And that's why she felt comfortable. I'm not saying she was trying to hook up with Miller again. She wanted to travel for work. And that's why she felt comfortable bringing, hey, we've been making progress, but, I got to travel for work, And then she says, my mom can come with me. That's what Gerhardt told you about. So this is them on the trip, the day before. This so-called big plan. There was no big plan. Now, why are they committed to saying that there was this pre-plan and financial motive? Well, because of course, it makes no sense anyone would have syringes on this hike unless this thing was pre-planned from earlier. So they have to stick to that, even though it makes absolutely no sense. There was no plan. And I got to tell you, I got to tell you, okay. When they get into the fact that in like December or whenever it was, there's a text message where she's like, are you coming home soon? And he's like, this lady just got hurt on a hike and a rock fell on her, so I'm trying to save her life. The fact that they're trying to say that at that time, the light bulb went on in his head and he was like, I got it. I can kill her on a hike with a rock.
Objection.
That's ridiculous. That's ridiculous.
And a move to strike. Granted. That's our
Okay. Well, that's what he was pointing out.
objection against the improper argument. Sustain.
Too many objections here.
The idea that he came up with this plan because he was trying to save a patient's life who was hurt with a rock on a hike is ludicrous. So, ladies and gentlemen, as much as they want to avoid it, as much as they try to talk about witnesses and corroborations, the reality is this. What happened on the mountain before the hikers got there, it is essentially she said, he said. The witnesses told you. They didn't see much. One witness only saw one hit. The other didn't see a hit at all. One of them picks out the wrong person in the photo lineup. Okay. Everything before that, they told you they can't say what happened. They don't know how it started. It's she said, he said. Now, by the way, these witnesses who apparently stood there and stared at him for 30 seconds, looking into his deep, cold eyes, they didn't see no syringes on the ground. You know, the one she says she flicked out of his hand that landed right there? They're nurses. They didn't see that because it didn't happen. The point is, ladies and gentlemen, when it's your burden of proof, it's this high, and it is she said, he said. Your she said better not offend logic, reason, and common sense. Better not offend be contradicted by the physical evidence. Better not be highly motivated. Better not have examples of many times where she was deceptive to the police and to you. And all of those are present with her testimony. I'm going to walk you through that. Now, logic, reason, and common sense. The bottom line is Ariel König is not reliable. She's not reliable. We talk about credibility. The question is reliability. Okay? Logic, reason, and common sense. We don't ask you to leave that at the door. We want you to bring that in here and look at what was said. Let's look at what she said, right? I mean, basically she's saying she wouldn't take the selfie, and then he was like, I'm tired of this shit. Let me throw you off the cliff. And then he tries to stab her with a syringe, and he's loading it first, and then he bashes her up to 10 times. That's her story. Okay. First of all, the way she describes it makes it sound like he had multiple arms, like an octopus. She says that she's covering, he's on top of her, covering her mouth, and then he has a syringe, and then he's loading he has a vial, and he's loading it, but he's holding her down. Can we approach, Your Honor?
Sure, come on.
No. So this guy has done a defense argument. It's not effective at all, in my opinion. I think he's coming across way too aggressive. This is a crime of violence, and you're going to have your attorney, if you're Dr. Gerhardt König, your attorney's going to come across aggressive. Aggressive is the only mode he's really gone here. He's talking very fast. He's not relying on notes much, but he's sort of meandering around and just trying to naysay everything the prosecution's trying to do. So he hasn't come up with a theory of what actually happened yet. He's just trying to poke holes at what the prosecution has presented, and I don't think he's doing an effective job at all. And so I'm not sure why the prosecution is doing a lot of these objections. It's just not a common thing you see.
Why would you have a vial unless you're trying to load it? He has a syringe in his hand. The other hand, he's holding her mouth. He's down on top of her, doing all of this while she's supposedly kicking and fighting. He only has 2 arms. And in the middle of it, they're having a full conversation. Your mom's not going to be very happy if you do this. You know, the kids aren't going to be, you know, her story makes no sense. Now, logic, reason, and common sense, as we look at her story, and it is a story, okay? If we look at her story, why, if this was a big plan that someone's going to bring a syringe to incapacitate somebody and stab them to make it easier to throw them off the cliff, don't you think they would load the syringe ahead of time? Don't you think they would load that syringe ahead of time? Their story is that he's that's the plan, and in the middle of it, he's like, oh wait, I gotta take out this vial and get it ready.
That wasn't the primary plan, though.
Especially given the fact that it's undisputed, he had just gone up the mountain by himself for 10 minutes. If he had it and wanted to use it, he could have loaded it. It makes no sense because it didn't happen. It didn't happen. The other thing, and I'm glad he brought up this thing about plan A, plan B, plan C, because it proves the point I was going to get to. Why in the world, if you bring a syringe to incapacitate someone to make it easier to throw them off the cliff, Why would the syringe be plan B? It would be plan A. You would use the syringe first, and then you would throw him off. You wouldn't start the scuffle and make that, start this scuffle and then be like, oh, wait, now I'm going to stab her with the syringe. That makes no sense. It makes no sense that, that's the plan. He knows if something like that happened, he's a doctor, and toxicology report would show propofol in her sting, in her blood, that this is
not an evidence.
It makes no sense that he would start the scuffle before using a syringe if that was his big plan, because it didn't happen. This idea that she could just flick the syringe out of his hand, he's holding it tight, according to her, just flicks it. None of that makes any sense. This idea about, well, he hid evidence. The rock is found right there. We don't know exactly where because HPD should have photographed it before they moved it. But why would he get rid of the syringes and leave the rock? None of that makes any sense. And then, of course, we get into him leaving her on the mountain. Leaving her on the mountain. If this is a big plan to use this hike as an opportunity to throw her off and kill her, why would he walk away and leave her there alone thinking he's going back to the car? And they're trying to say, well, all kinds of things about that. But the reality is this. If you think, even though it's not true, if he went off on his own, because if she said, well, it's too high, I'm getting a little scared, and his plan was to kill her, he wouldn't leave her. He would say, okay, you know what, that's fine, but let's just at least go over here and take a selfie and then try to throw her off, right? He wouldn't have left her for that reason. If he was planning to try and throw her, he would have stayed with her. And then her rationale, it went, to get around the idea that undisputable that she clearly said when he got back, she told the detective that he said, oh, you're still here. He was surprised that she was still there. She says, well, he knew I meant I was going to go exploring in that area. Where was there to explore? We heard from witness after witness. It was you either go up or you go down. You don't go off and go exploring. That was her way to try and cover up. That it was clear he left her thinking she was going back to the car, which you wouldn't do if you had a plan to kill somebody by throwing him off the cliff. TSA, we've all been through it. Sharp metal syringe objects, sharp objects, not going to work. Not going to work. Logic, reason, common sense that he has this intent to kill her, but then he lets her crawl away. He lets her go down to the
people
witnesses.
showed up.
After.
This is such a weak
Doesn't
argument.
make any sense. Her demeanor. They say, oh, she was very matter of fact and just told it. Ask yourself, if someone's describing what should have been the most horrific thing they've ever been through, bloody murder, someone's trying to stab you with a syringe, a monster's trying to throw you off a cliff. When you're recounting that, you might get a little emotional. Not at all. And she's not just someone who doesn't get emotional, because we saw her get emotional when we showed her the card. When she read the birthday card, she got emotional. I submit to you that was probably guilt, but whatever it was, she knew it was genuine, and she showed an ability to show emotion. That was real. The card was real. You cannot get emotional over a made-up story that didn't happen when you started the fight. Reasonable doubt, logic, reason, and common sense. Now, Ariel's story contradicts the physical evidence. It just does. And this is a huge problem for them. And they try to come up at the last minute with, well, maybe when blocking it, her DNA got on it. But let's talk about that. Because we're talking more than probably, right? He wants to say maybe blocking her DNA got on it. Maybe. Okay. But let's use our logic, reason, and common sense and look at the physical evidence. What does Scott Henderson say? The DNA got it. Generally, yeah, you could expect higher likelihood ratios with the more DNA that's present in a sample. The more DNA present in a sample, you can expect a higher ratio, yes? Generally speaking, yes. The more someone's DNA is on the sample, the higher the number. Higher the number. He then goes on, we learn from him and Amarin, that, very important, the rock. Swabbing from the unstained area. There was a stained area that looked like blood, and there was the unstained other side. They swabbed the blood. They tested. Of course, it's Ariel's blood. I told you that in opening statement, right? The blood side was Ariel. The unstained side, they don't test for blood. They test for human skin cell touch DNA. from people holding objects they told you. Okay. The unstained side had a profile for two people, Ariel and Gerhardt. Ariel's number was 1 trillion. His was 290. Let's go back to what Henderson said. The more DNA present on the sample, you can expect a higher ratio. Yes, yes. 1 trillion to 290. The rock was in her hand. The rock was in her hand. The DNA shows that.
This guy's bouncing around.
That blows away her whole story. That she didn't have the rock. The rock was in her hand. Her DNA is all over that. This idea, well, maybe when she was blocking it hit her, that's not going to lead to that much of her DNA on it, more than him.
Objection, speculation.
If he's holding the rock the whole time and she's just blocking, there's going to be more of his DNA than hers. She was holding the rock, and that blows away their entire theory. Scientifically, I asked Amarin, what about scientific evidence, Miss Amarin? And we talked about it. It's unmotivated. Scientific evidence is not trying to get full custody. His retirement. It doesn't lie. It is what it is. And they may say, well, maybe it was there because of this. Again, maybe, maybe not. A huge reasonable doubt. A huge reasonable doubt. She had the rock in her hand. 1 trillion to 290. Now, the other thing about the physical evidence is the injuries. They want to say, we heard about the stellate laceration. I'm going to talk more about it later. But it has one point and it spreads, right? And you heard, she at the end said she doesn't know how many times she was hit. The doctor, Grosjean, said 2, maybe 2. I cannot say how much more. Dr. Arden says 2 to 3. Okay. If she was hit 7, 8, 9 times with all his might, it would be way worse. Physical evidence doesn't support her version of events. Also, if she's under attack, she's going to be scratching, doing biting, as she says. He has no scratch marks, defensive wounds. There's no bite mark on him, even though she said she bit him. The physical evidence doesn't support her story. And that's a huge problem when it's this she said, he said, and this is your burden. That's a huge problem.
It's not a he should.
Further
She
problematic is the examples of deceptive behavior that we saw through her. Many examples of deceptive behavior that makes her unreliable. We heard about her deleting the text messages to hide it from her husband, to hide the extent of her relationship. That is inherently deceptive to do that. It showed that that's inherently deceptive. Now, the affair. Look, I'm not the morality police, okay? I'm not here saying she's an awful person because she had an affair. That's for you to decide, okay?
Objection,
The relevance.
improper.
Sustain.
And move to strike.
Last argument on morality is stricken from the record.
The relevance of the affair is primarily that she lied about it to the detective. The context is showed in the relationship in January, February, and December, but the relevance is she lied about it to the detective. And that is incredibly important when it is she said, he said, and it's proof beyond a reasonable doubt. Let's look at this. This is, he said, well, she describes it to the detective as just some flirty text messages. He says, well, there's nothing in the text messages about sex. Well, she deleted most of them, so we don't really know what's in there. But we do know what we saw. On the trip, the day before he's going to confront her, this is at 11:22 p.m., presumably Hawaii time, or maybe it's California time, whatever, but it's late at night. She's sending this to Jeff Miller. Jeff Miller is sending her this. They have a nickname for Gerhardt, HALU, which is that radiology, nuclear, whatever. They call I have HALU. They have a code word to let each other know when he's around. She's listening to an audiobook, How to Help My Spouse Heal from My Affair. That's what she's listening to. He says to her, you're engaged and continue an elaborate secret affair instead of coming to me asking to work on our relationship. And her response is, if anything, I learned how stupid it was this time and I know how to make sure it doesn't happen again. That's her response. Okay? Now, to the detective, no affair, just some flirty text messages. To you guys, no affair, just some flirty text messages. You saw 12/1, December 1st, all day long on a Sunday. Good morning, all day long, all day long, all day long, good night. And that's how she says it to the detective. She was misrepresenting, deceptive, lying to the detective. Further examples of deceptive behavior is what she does with her primary care doctor and the records. After the fact, she tells her primary care doctor in an email to add, can you add traumatic brain injury? I want to make sure the documentation is consistent between my care at Queens back here in Mount. And that's the important part. Why is that important? Because, number one, she says she doesn't recall reviewing the Queens records. The Queens records doesn't mention traumatic brain injury. Arden told you that, the two don't you think if traumatic brain injury was in her Queens records, they would have asked Grosjean or Carlton Whitney that? It wasn't in there. So this shows she is not just asking the primary care doctor to do this, she's deceiving the primary care doctor into believing that the Queens record said traumatic brain injury, so the PCP will be like, oh, okay, I'll add it. It's deceptive behavior. It's incredibly misleading. Now, she says she's surprised about the work bag. She's surprised about the work bag. Oh, I didn't know. She knew he had it there. She knew there was syringes and vials in there. She calls her attorney. And then they turn it in and say, oh, surprise, look what I found. She knew it was there. She knew it was there. She lied about that. She lied about her affair. She lied to her primary care doctor. There is I really like quotes. So there's an author, famous author by the name of Samuel Clemens. Most of us know him better as Mark Twain. Mark Twain was giving a speech once to some young people about the dangers of being untruthful. And what he said was, you ought to be very careful about lying. Because once caught, you can never again be, in the eyes of the good and the pure, what you were before.
Objection to improper argument.
It's not
You guys come in
improper.
here,
Gosh,
you give people the benefit of the doubt. They come in here, you say, I'll hear them all. And then they lie about different things. They deceive. In the eyes of the good and pure of all of you, you can't look at her the same again. It's dangerous. It's dangerous. If she's going to manipulate her PCP doctor, if she's going to be deceptive to the detective, do you think for a second she would hesitate to be that way with you? And then we get into bias, interest, motive. We talked about this. How she knew a divorce was coming. She wanted full custody, how they're using these allegations against him to get full custody, to make it where he can't ever see his kids again, to get half his retirement, to get all of the house, things that she might not get. She knows that. She said to you that their statement is, we want full custody, but if depending on the outcome of the case, that can be revisited later. She knows the ramifications. Now, let's compare that to Dr. Gerhardt König. You got to see him. Trust your gut. Trust what you know about people. Is he somebody that is a monster that came up with this plan to stab his wife and throw her off a cliff? Is that the sense you got from him? Or was he a hurt human being struggling with infidelity but trying his best? They talked about his parents, how they moved from South Africa when he was young. He worked really hard to become a doctor. he talks about, oh, she was trying to control everything about her. All of this awful controlling guy. What does she say? Prior to December, you generally describe your marriage as good, right? Yes, sir. This is what Ariel said. You don't describe your marriage as good if somebody is a controlling, coercive, violent person. There's a lot embedded in this. You don't describe it as a good marriage if somebody's, unless they're a good dad. Look, domestic violence is horrible. There's some awful men out there that use their power, control, financial means to control women in improper ways. This is not him. That's not him. She wouldn't say it was a good marriage if he was like that. His version of events, they fault him for wanting to see her phone and things like that. The audiobook said that's what it takes. This is Ariel. I asked you earlier, you understood the audiobooks you're listening to by these professionals says to give up privacy, give up access, get them to trusting it. She says yes. They're faulting him for the professional advice, what is said. He's not trying to deprive her of her career. He's trying to stop her from seeing the guy that she had an affair with. He was fine with her getting another job. That's a very human thing. Why would you be okay with her going back to work with the guy that she had an affair with? Now, he went into detective mode when he found out about the affair. That's a very human reaction. Very human. He was on the computer looking up Reddit and infidelity and getting some advice. It's not easy when your partner cheats on you. He's struggling with it. They're making some progress in January and February because counseling, she turns it not about the affair, but about other issues. But they're making progress. They're kind of heading in a good direction. They go on this hike. And it makes sense that at that hike, she brings up this issue. Again, not that I want to be with Miller, but hey, I got to travel for work. Okay, I got to travel for work. And this is a detail that you just can't make up, right? He says, then when they're fighting about it, she said, well, my mom can come with me to chaperone. He leaves her because they got into a fight, not because she's afraid of heights. She goes on all kinds of bungee jumping hikes all the time. He comes back and he's like, oh, you're still there. He described to you what happened. He's not saying, oh, he grabbed me and pulled me down. The scuffle started on this mountain trail and they ended up on the ground. Whether they tripped or fell, whatever, he ended up on her. And then he told you how she's grabbing his testicles. And she admits to it. And then I also squeezed his testicles. That's her testimony. It was all happening so fast. We spent a lot of time going through it all. That's not real life. In real life, you don't get hours to be like, okay, and then you did what? Well, why didn't you do this? Well, did you consider that? Did you consider doing this with the rock instead? It was happening in seconds, and he reacted, and he had a reflex, and that's human. That's human. That's human. He reacted. And then he felt horrible about it. And he told you about that. He never wanted to hurt her. Never. He felt terrible about it. He was shocked that he could do that to her in that moment. He felt horrible. The physical evidence supports his story. The DNA, and I'm going to get into the medical evidence a little more in a second. You have this, which apparently might have been dirt. Undeterred, might have been dirt. You have a cut, you have bruising. Right where he said he was hit. Reasonable doubt. Now, the FaceTime with Emil that they call a confession. There's no assurances of reliability. He explained to you what happened in that call. We need to consider it in the context in which it took place and ask ourselves, is this a reliable thing that happened that we can rely on? Two highly emotional participants in the phone call. One is suicidal. One is thinking his life is over. He's very emotional, calling his son to say goodbye. The other, obviously, not blaming Emil at all, incredibly emotional. His grandma said she was shaking, crying. Two very, very emotional people. Then you look at the environmental factors. He's on the side of a cliff. And they made it a point to get the HPD officer to say, it's very windy over there, notoriously windy. Very, very windy day, according to the police. He's on speakerphone on the side of a cliff talking. And he told you what he did. He was explaining to her, look, she was having this affair. She got hurt. This is her blood. She crawled away or got away. She crawled away. And she said, I tried to kill her. He was telling her that's why he was going to end his life. He wasn't confessing. He was telling her, that's why I'm going to end his life. Now, we know this is his testimony. So as you see here today, there's parts of the exact wording and timing of what was said that you don't quite remember exactly verbatim, word for word, correct? He said yes. He cannot tell us exactly word for word what was said. And then we have an example of him making assumptions. He first tells the detective, my dad said he tried to push her off the cliff. That's what he assumed. Not blaming him, that's what he assumed. But later on in the conversation, in the interview, the detective asked you about that, and he clarified, he said, the part about her pushing her off the cliff was what you assumed he meant, not what he actually said, correct? He said, oh yes, correct. So we have an example already of him saying something that he assumed that wasn't accurate. He wants to say, it was so clear at the end of his redirect, he said, without a doubt, I know what was said. Do you recall how he had to try 4 times? The first 3, Emil said, yeah, I was confused. I'm kind of confused. And he asked again, yeah, I'm kind of confused. I'm kind of confused. And finally, Emil understood what the prosecutor wanted him to say and agreed. I'm not faulting Emil at all. Okay, this was a misunderstanding. The second call shows that. Gerhardt calls the second time, and he wasn't saying, why'd you rat me out? He was saying, wait, what? You told Ariel's parents I tried to kill her? Oh, like, I gotta go. And he was gonna go kill himself again. This idea that he wasn't giving Ariel a blow-by-blow what happened, Emil a blow-by-blow what happened, he was trying to say goodbye to his son. This is not a confession they're making it out to be. I just point out to you, it's not his fault. He's lived with Ariel the last year. He wants to be on Maui. He likes it here. He knows the only way he can stay here is living with her. We talked about her and her actions with the detective and the primary care doctor. He understood what the prosecutor wanted him to say after the 4th try. This was not a confession. Gerhardt's actions after the incident, they want to say it's consciousness of guilt. I say it's conscious, it's proof he's human. He went into deep despair. He couldn't believe that he could cause that kind of harm to the person that he loved. And that can coexist with defending himself in the moment, in that reaction.
And then he walked away.
Horrible about it. He went into where he was suicidal. What he was saying to Emil on the phone was, I gotta go. I don't want the police to find me. Is because he wanted to keep open the option of killing himself, which was turning to be harder than he thought. He didn't want to get caught at that time because he was still thinking about jumping and killing himself. He wasn't evading the police for the purpose of, I don't want to get caught. He wanted to be able to kill himself and have that option. And we'll talk about when he turned himself in later. And that's why he did what he did with the SIM card. He didn't want the police to find him because he's thinking about killing himself. And this idea that in the middle of this suicidal place of being super emotional, that you open your SIM card, you bend a paperclip, open it, and you're going to take the time to put it back where it was instead of just leave it over there. It shows he's human, that he felt terrible about this. He told you how bad he felt. And that can coexist with self-defense. Now, this idea that he was fleeing from the cops, first of all, the officer didn't say we pulled up right next to him. Very clearly, they said we pulled up. There was a lane in between us, and he was on the grassy area. This grassy area right here. They said he was here when they got out of the car, and he started to flee. And remember? And I said, come on. How the heck was he not going to get in the bushes if that were the case? And then, shockingly, the prosecutor asks him, well, you played D1 football, right, officer? I mean, the fastest man in the world, Usain Bolt, Olympic sprinter from Jamaica, could not get to him from the car if he's trying to get into the bushes. Look, I get it. Officer safety. Look, I'm not faulting them. They came in hot. They're the strategic enforcement detail. Apparently, you got to be 300 pounds to be in it. I get it. They think he has a syringe. Okay. They come in hot. They couple strikes, don't hit him in the face, and arrest him. I'm not faulting them for that. I don't know about this, saying he was trying to flee. Okay, that's not cool. Okay. But I get it. Officer safety.
It's not cool. That's all you have to say about it. Conscious
He has an
guilt.
injury. Look at this. It's dry blood and it's bruising. It's the kind of purple bruising that takes place hours later. When you first get an injury, it doesn't bruise. This happened earlier. Dry blood, purple bruising. That takes time to get to that point. A theory and search of facts. I talked to you guys about this. To try and use a computer to manufacture financial motive without telling us last week that sometimes, I'm sorry, how much time is that? Thank you. That sometimes the computer opens files and shows it was access. Don't you think that would have been fair to tell you guys that? Instead of leading you to believe that 100% Gerhardt looked at all of these things? Look, make no mistake, he said 80% of it he looked at. He's not hiding that. He's just, when he's up here saying, like, I don't remember at 3 a.m. looking at a 2018 Amex credit card statement that was in my old divorce file. And, but undeterred. It shows he had a financial motive. He was looking up how much his divorce costed him in the past. What? He makes a lot of money as a doctor. The search terms: kill, push, shove, syringe. They're looking for the smoking gun. They have had it with his computer. Looking for the smoking gun. What do they find? No smoking gun. Just some search about hikes that you would search if you were truly just going on a hike. Again, maybe, maybe not. They're looking for a smoking gun. They don't find it. So what do? They manufacture a motive, undeterred, theory and search of facts. Oh, no smoking gun. But you know what? It shows he's looking at financial documents. He has a financial motive. It's not fair. I submit to you that whatever they found on that computer, they would find some way to spin it. Whatever they found, they would find some way to spin it. That's not fair. The work bag. And this, I gotta say, he uses these tools and materials to save lives. And they want to fault him for having it? He's a doctor. He talked to you about why he has it on Maui, not on Oahu. He uses these things to save lives, not try and somehow poison his wife.
Didn't try to save her on the cliff.
And she knew he would take it from work every day. Now, self-defense, first thing you got to decide is whether or not this was deadly force that he used. We know it wasn't. We're going to get into that in a second. But it doesn't matter either way because it's the same rock that she hit him with. So even if it was, even if you say it was deadly force, it was the force that was used against him. So it doesn't matter. It's the same rock. The only thing it does say about it, and this is the part that was incomplete, about the duty to retreat. It says, the use of deadly force is not justifiable if the defendant knows he can avoid the necessity of using such force with complete safety by retreating. You only have to retreat if you can do so safely. She's holding on to his testicles, hitting him. And it just talks about being reasonable. He used the same force that she used against him. And they want to say, well, look at the difference. How could it be the same rock? Obviously, if one gets hit cleaner than the other, the same rock can do that. Like I could throw something at a baseball at someone's head, and one it hits them in the face, and one it hits them in the arm. It's going to cause obviously it can be depending on how the direction, how hard the landing was. He stopped. He didn't keep going. What amount of force was used? We know, like I said earlier, we know what Ariel says she doesn't know. I don't know the exact number. They are downplaying what she said because they know it doesn't make sense. They're saying, oh, up to 10 times. So what does that mean? 6, 7, 8, 9? Doesn't mean 2. But now they know that doesn't make sense. She was hit 8, 9 times. So, oh, maybe she meant less. She doesn't know. Grosjean says possibly 2, maybe more. I cannot tell you. Arden says 2 to 3. He says 2. Grosjean talks about, oh, there's rock in there or dirt. He's not a forensic pathologist. He didn't test the material just to show like what it was. Her condition after. You saw her walking. She's walking on the hill. Okay. But more importantly, this is her talking after. And I'm going to ask you to do something with me now. If you could help me out here. Either close your eyes or don't look at the screen and just listen to her voice.
You got stopped by 2 witnesses.
Where does he work?
He works for TMG at Maui Memorial Medical Center. TMG's called it.
At Maui Memorial.
Memorial, yeah. So TMG's a group of anesthesiologists.
Did you guys drive here today?
Yeah.
Which is your car?
It's a Nissan Rogue.
Do you remember the license plate? If not, that's okay.
It's not our car, but I'm on now.
What color is it?
Strangers have to show up because you can't help her, really.
Let me just wet my mouth. Go wet paper towel, putting my mouth full of Botox. I don't have any more on me, so. Sorry, I know. No, you're an angel. Trying to stop the bleeding until they get me. I know. I really wish.
What was Gerhardt wearing today?
Wearing like a light gray shirt and
Okay. Does she
How's that
sound
helping
like she
you,
has a
Ted?
traumatic brain injury too? She sounds okay. Look, I'm not saying it wasn't a bad cut. And look, I'm not, nobody wanted her to have that cut. I'm not saying it's not, I'm just saying the level of force he used, you can see. He talks about chunks missing from his scalp. No doctor said that. It was soft tissue. You heard from Dr. Arden, a very credible man, that apparently for 14 grand is going to sacrifice his integrity. Obviously, he's not going to do that. He told you the blood is not a good indication of the severity. The blood is not a good indication of severity. No skull fractures, no soft tissue. The tip of her thumb, he said it was just the very tip. And sure, after the first hit, he puts her thumb, it hits it. Just the tip is fractured. We heard about that. All 3 doctors agree. No substantial risk of death and no serious bodily under the law. All 3 said that. We talked about the stellate laceration. The Glasgow coma score was 15 out of 15. Triage, they waited a few hours outside because she wasn't in that serious of a condition. She had a bad laceration. They sewed it up. She went home the next day. And I don't mean to. He feels terrible that happened. But he wasn't trying to kill her. That's about the amount of force that was used. Now, her eye. Let's look at this photo. The orbital is the most fragile area there is. And he said, very fragile bone. If he hit her with that rock, it would have broke bones. There was a scuffle. They landed on the ground. They're fighting. There's elbows. He's going for the rock. They're fighting for it. There's no doubt her eye got hurt in this thing. But he didn't smash her eye with the rock the way they want you to believe.
He's not as aggressive now, but he's...
And then you have his injuries. We talked about that. Now,
not
it's
making
the
sense.
state's burden to prove to you this was in self-defense. More than probably. that it wasn't under the circumstances, that he reacted as a human when she was doing these things to him and hit him. They have to prove to you it doesn't apply. It was a reflex. It was a reaction. It was a human reflex and reaction to defend himself in the moment. And that can coexist with him feeling terrible about it after. This happened extremely fast, and then he stopped. Now, we talked about the elements of attempted murder. He had no intent to kill her. You see on the bottom, and self-defense applies. They have to disprove those two, self-defense. Then there's something that takes you down to the others, right? The other offenses. If and only if you find the defendant not guilty of attempted murder, then are unable to reach a verdict, unanimous verdict, then you must consider these other included offenses. None of them apply. Self-defense is a defense to all of them. If you think that they didn't disprove self-defense, it goes all the way down. But you work your way down through these things. I'm just going to go through it quickly because I don't have a lot of time. The next one is attempted assault in the first degree. That he took a substantial step in conduct intended to culminate in the commission of assault in the first degree. That he intentionally or knowingly was trying to cause serious bodily injury. Let's look at the definition of serious bodily injury. Serious bodily injury means bodily injury which creates a substantial risk of death or which causes serious permanent disfigurement or protracted loss or impairment of the function of any bodily member or organ. The doctors say she didn't have that. He wasn't trying to do that. This doesn't apply. Self-defense, no intent to cause serious bodily injury. You go on to assault in the second degree. Again, no intent to cause serious bodily injury. Self-defense applies to all of this. So you work your way through, self-defense applies to all of it. Her motive to try and get custody and conviction of any of these things helps her with that. Assault in the third degree.
For improper instruction of the law.
So should be substantial. Ladies and gentlemen, we have the instructions of the law. That's the instruction of the law.
Then you get to assault in the third degree, bodily injury or negligent use of a dangerous instrument. Again, self-defense. He wasn't negligent. He was reacting. Reasonable doubt as to every one of these included offenses. So you just work your way down. And then there's something after that called a mutual affray. If this was a mutual affray. Reasonable doubt as to all of these. Now, I'm almost at the end here. I have couple more minutes. I want to end by saying a few things. This is the law. I ask you to use this as a guide to your deliberations. It's not about trying to figure out what happened. Your only goal is to answer the question, is there a reasonable doubt? Did they prove beyond a reasonable doubt this was not self-defense? More than possibly, more than probably. Let that guide your deliberations. It's a way to simplify things. After you talk about any piece of evidence, come back and remind each other, yeah, but does that prove this beyond a reasonable doubt? Let that guide your deliberations. I couldn't help but think last night. When they moved here to the United States, there's these constitutional rights that we all have. They didn't know it at the time, but it was for a moment just like this. When a jury of his peers would come together and follow the law and follow through on the oath that you took. I want to end with a quote. There was a politician back in the day who was giving a speech, and it was to other politicians, but I think it applies pretty well to jury service. It says, for those to whom much is given, much is required. And when at some future date, the High Court of History sits in judgment on each of us, recording whether in our brief span of service, we fulfilled our responsibilities to the state. Our success or failure will be judged by the answer to 4 questions. First, were we truly men and women of courage? Second, were we truly men and women of judgment? Third, were we truly men and women of integrity? And finally, were we truly men and women of dedication? I ask you to keep those 4 things in mind as you deliberate. Courage to follow the law and do what's right, even if it may not be popular. Judgment to see through some of this ideas that he had a financial motive, that it was cheaper to kill her. Common sense judgment. Dedication to these principles and our Constitution. Dedication to it. Uncompromised dedication to the presumption of innocence and reasonable doubt. Deliberate that way. Uphold your oath. Follow the law. Let this guide you. Enforce the reasonable doubt standard. Follow the law. Do these things. And integrity will be yours. Thank you for your time over the last month. On behalf of Dr. König and Manta Dirks, thank you all for your time.
All right, we're going to have a rebuttal here. We're going to have lunch.
Appreciate it.
The jury's hungry. They didn't want to listen to any more argument. But the prosecutor needs to argue. I'd keep it 5 minutes. Okay, 5 minutes. Jury's hungry. Keep that in mind, prosecutor. 5 minutes. 10 at most, and go sit down. Be ready to go. Come on.
Mark Twain also said, if you tell the truth, you don't have to remember anything. Think back to defendant's testimony. Think back to every time he was asked on cross-examination something that made him look bad, something that made him look like he had a motive, something that was incriminating. Think back to every single time the defendant was asked something like that. And what was his answer? I don't recall.
Mm-hmm.
Ariel König was able to sit here and testify in front of you for 3 reasons. First, she had her intuition. She saw the defendant looking at her feet on that trail. She saw the defendant tracking her every move. She saw the defendant making sure he saw where she was. And that's what made her feel uneasy. It was her intuition. Second, she fought back. She fought for her life that day. And defense wanted to characterize it as a full conversation, but it was Ariel begging for her life from the defendant. It was Ariel saying, think about the kids. It was Ariel saying, nobody's going to believe this was an accident. This is Ariel trying to reason with somebody who is trying to kill. And the third reason and the most important reason that Ariel was here to testify to you is Amanda Morris and Sarah Bucksbaum hearing a call for help, going forward, looking at what they saw, and helping Ariel out. Because the evidence shows that is the only thing that stopped the defendant that day. The only thing that stopped him from continuing to beat Ariel with that rock, from continuing to hit her, from continuing to try and kill her, was Amanda Morris and Sarah Bucksbaum catching him in the act. Defense wants you to think about the life insurance. But you should think about it differently. This is a couple who's going through it in their marriage. Why is it time to renew life insurance? Does that make any sense? No. What the life insurance is, what many of defendant's actions are, is the defendant covering his tracks. The cover-up proves the crime. Defendant had control of the scene when he was done, so he took the evidence with him. He didn't need to take the rock. In fact, he knew that he was seen with the rock. He knew that Amanda and Sarah saw him with the rock. Why take it? And what reason would Ariel have to make up the syringe? None. Think about what Ariel knew. Ariel knew that he had tried to push her. Ariel knew they were right next to a cliff. Ariel knew that people walked up as she was being beaten with that rock. She had enough already. There's no reason to make up the syringe. Defendant's attorney said something. These are the facts you just can't make up. And that's what the syringe is in this case. It's a fact you just can't make up. Let's talk about the confession. Emil told you he has no doubt about what the defendant told him. If this was truly a goodbye phone call, if this was truly the defendant telling his son that he was going to commit suicide, what purpose at all would there be to accuse Ariel of having an affair? What purpose does that serve in saying goodbye? That makes no sense. It's just trying to throw dirt on Ariel. That's all it is. It's trying to throw dirt on her. It's trying to make her look bad. It's trying to justify his actions because he knew from the minute he did it, and he knew from the minute he planned it, that it was wrong. And then look at that timeline again. Why? It makes no sense. The defendant was simply trying to say goodbye. It was simply a miscommunication between himself and Emil. If it was a miscommunication, why wasn't it cleared up? Why wouldn't he just tell Emil in that second phone call? Why would in neither of the FaceTime calls the defendant say anything about self-defense? Why wouldn't the defendant say anything about Ariel supposedly attacking him? Because in that moment, he was confessing. In that moment, he had a guilty conscience. And that's why he did what he did. That's why he hid. That's why he tried to run from the police. Think about the list of people that would have to participate in this, what essentially is being alleged as a massive conspiracy to believe what defendant's saying. You have to disbelieve Ariel. You have to disbelieve Emil. You have to disbelieve Amanda. You have to disbelieve Sarah. You have to disbelieve the medical evidence. You have to disbelieve the doctor that the defense hired. And you have to disbelieve what you saw with your own eyes. That's why the defense asked you to close your eyes when they played that video. They wanted you to ignore what you see. That's what this case is about. That's what they're asking you to do. Open your eyes, make a decision based only on the evidence, and the decision is clear. The defendant tried to kill her. The defendant tried 3 different ways, and he learned out multiple times that day. It is harder to kill. than you may imagine. You were told earlier about the defendant's constitutional rights and the founding of this country and how important that is. What are those three phrases that this country was founded on? You've probably heard them before. Life, liberty, and the pursuit of happiness. And in this case, the defendant, beyond a reasonable doubt, made a conscious choice to try and take Ariel's life. He made a conscious choice to kill her. And that is why the only verdict that is supported by the evidence is that the defendant is guilty as charged. Thank you.
All right, glad he kept it short.
Thank you very much. Just about to send the jury in for deliberation. Before I do, to the first 12 jurors, is there anybody here who feels for any reason they cannot participate in deliberations in this case? I see no hands. So that means Mr. Kiyama, Ms. Kishi, Ms. Pang, and Ms. Yang, I'm able to let you go, but you're not quite yet done. If one of the other jurors cannot complete deliberations, you may get a call to come back and participate in deliberations. Okay. So even though you get to go back to your regular lives and you're not sitting here in the courtroom, those three rules still apply. Don't talk to anybody about this case. Keep an open mind. Do not try to learn about this case outside of the courtroom until one of two things happens. Number one, you get a call to come back. Or number two, you get a call letting you know that deliberations are complete and the case is done. So unless or until you get one of those two calls, those three rules apply. Don't watch any media, just in case you might have to come back and do further jury service. On behalf of the parties and the rest of the judiciary, thank you very much for your time and your service. I talked about Gold Star jurors early on. They were weathering the two storms to be here, and all the flexibility and perseverance that all of you showed. That still remains true today as more storms come our way. So again, thank you very much for your dedication, your perseverance, and your service. If I do not have a chance to talk with you later on, I hope you and your families remain safe during this upcoming storm. And again, you have our gratitude. Thank you very much for your service. Feel free to leave the courtroom.
All right, so it sounded like 4 female jurors were excused as alternates. So, assuming those were 4 of the 12, so now we have.
Thank you. So, ladies and gentlemen of the jury, as you already know, lunch is going to be brought in for you while you're in the jury deliberation. I do have a couple of final instructions before I send you in. Your deliberations take place during what I call banker's hours. So you're allowed to deliberate up until 3:45 today. If you're unable to reach a verdict, I ask you to come back, start again at 9 o'clock. And the reason why if you ask why is it so early, because if there is a verdict, there is time needed to assemble everybody to receive the verdict, and it won't happen before the end of the day. So that's why I released jurors at 3:45. Have you come back at 9 o'clock if you don't reach a verdict today. You will have communication forms along with the verdict forms that will go into the jury deliberation room along with the exhibits. One note about the communication forms. If you do send a communication to the court asking a question, it does take some time before an answer can come back to you. Sometimes it takes up to 45 minutes, sometimes an hour. If you're waiting for a response, if you can continue on with the deliberations, please do so. A couple of other things. You will not have the opportunity to ask for any additional information that you think is helpful. So you have all of the evidence that's available to make your decision on this case. Also, there are no transcripts available for the testimony of the witnesses. So you have to rely on your collective recollection as to what the testimony may have been. Before I send you in, is Calvin, Ms. Alvin Fisher. Will you stand and raise your right hand? To both of you, solemnly swear or affirm that you take this jury in charge, that you will not communicate with them except by order of this court, that you allow no one to communicate with them, and that you'll conduct them into court again whenever so requested by them or by order of the court.
Hello. Hello.
Thank you. So ladies and gentlemen, I'm going to ask that you take your notebooks, take your jury instruction packet, and all your personal effects as you go into the jury deliberation. All rise.
All right, so jury's being set out to deliberate at approximately 12:39 local time there in Hawaii, which is 6:39 Eastern time in mainland United States. So there's 6 and 6 females and 6 males on this jury. As I understand it, there was 10 females and 6 males, and 4 females got dismissed.
Mr. Barner, anything you want to place on the record before we recess?
Nothing to say, Your Honor.
Mr. O'Connor, anything you want to place on record before we recess?
No, Your Honor.
To all of you, thank you very much for the work that you put in on this case. I remain impressed by the lawyering talents. I haven't been here that long, maybe it's long for some people, but one of the true joys of the job is watching excellent attorneys represent their clients and apply their craft. And I'm truly privileged to watch that in this case. So thank you very much for excellent lawyering. Until we hear from the jury, court will be in recess.
Thank you, Your Honor.
Well, John, my brother's not there in the courtroom right now, but when he was there last week, he said it was, well, they're not really shaking hands there, prosecution defense. They got some bad blood between them. But it was 10 females, 6 males. It sounded like 4 females were dismissed. That makes it 6 and 6. Regardless, it's not going to affect the outcome of this case here. I think the state has proven their case beyond a reasonable doubt as to the attempted murder. And the defense their closing was not well presented at all. It was very disjointed. It started off with the law, talking about the law. Then they got into facts, and they tried to get in some of the jury instructions some later. And I just thought it was not a good flow. It didn't have ease of listening for the jurors, and it was very, very aggressive, especially in the beginning half to 2/3. It seemed like way too much energy, emotion, and I think jurors, you run the risk of scaring them off that way by being so over the top aggressive like that. So I think that in the end, the jury's going to go by the evidence, not the conduct of the attorney here. But he did seem to be very desperate, this attorney. So he didn't seem to have competence. The prosecutor, if you compare that to the competence of the prosecutor, look how competent he was. He never lost control of the case. I thought he was objecting way too much on this case. I've never seen a prosecutor object this many times to a defense closing. So in the end, it's most of that stuff I ought to let go. If he's misstating something, just clean it up in your closing rebuttal. But in any event, the defense also objected a couple times, so I thought most of those objections were out of hand and improper and irrelevant and not necessary. So the thing is, as an attorney on a criminal case in front of a jury, you really want to save your objections, and unless it's something really serious, you don't want to object to the other sides. It's just a professionalism you have. So I would, if I was a coach of this prosecutor, I would tell him, just let those objections go. It's got to be really something serious before you go into that objection motif. But in the end, although I think the prosecutor did an A job, I'd say the grade I'd give this defense attorney, he does not have a lot to work with, so you got to keep that in mind. And his only defense was trying to poke holes in the prosecution. But I would grade it being very easy on him, I'd grade him like a C minus probably. And I'm thinking I'm being sort of generous. It probably should be lower than that. But I understand he doesn't do a lot of criminal work per se. He doesn't advertise himself as a criminal lawyer, but overall, he got effective to assess assistance of counsel, constitutionally required assistance of counsel. The doctor did. But yeah, he was definitely, I think, defense counsel acting too desperate, was ping ponging around a lot, was bouncing around like a pinball too much of the time. I thought he settled down a little bit towards the end there, but it just wasn't something that I thought was very effective. But he did show that to have reasonable doubt, it can't be all these other things. It's got to be something stronger than that. He did not really explain self-defense well, either in facts or the law. The jury will see it for what it is. I don't think there's any way he can claim he needed self-defense to strike his wife on the head. It doesn't make any sense. None at all. To put those kind of injuries on your wife if she's going to get an argument with you and then it gets physical, you got to, because your wife is squeezing your testicles, you need to take the rock that supposedly you're saying she had and use it against her. No, sorry. There's just no way that sounds credible. And you're a medical professional. Really? Yeah. So the defense attorney overall, yeah. For the trial, from what I've seen, I would say the prosecutor did probably a B plus job, and the defense counsel did probably a C minus or D plus. Yeah, the nurses that showed up there that happened to be hiking, yes, they definitely, I think, saved her life. Matthew Smaldon, you think they overcharged? Well, if they did overcharge, then there's lesser included offenses. One of the ones was his assault in the first degree. They have to have serious bodily injury. I'm not so sure that they meet the requirements for serious bodily injury. But okay, Denise Hevicon, you're saying you've known Tommy Otaki for years. Jurors love him. His sister is a federal judge. I think you'll lose this one up. From my experience, I don't see how juries would like his approach, his over the top aggressive approach. You have to have likability, credibility, and trustworthy. I don't think he hits all those points very well. Yeah, he's just not a loving husband. He's a raging, out of control guy that did the worksheet up on what's it going to cost me if I divorce her. I don't want to deal with her anymore. I'm done with her. Or what if she divorces me? I'm going to be in such a huge financial strait situation. So the way he took off there like a little coward, no. So these people that are saying that he's not guilty, where are you coming from? Are you really that clueless to not see how this guy's acting guilty throughout this entire proceeding? He comes across terribly on the witness stand. And like I said earlier today, the way he comes across in his behavior, trying to control his wife, even if, I'll give you this, even if she was physically cheating with this other guy, the the bottom line is you don't take your matters into your own hands and resort to violence, extreme violence, like he was attempting. And I think that the defense, as I made a comment here earlier in the text on the chat, I think the defense really had this weird theory that they think they can go ahead and keep mentioning the cheating, the infidelity. They use words like interfere with, infidelity, all this kind of stuff. So I think they ramped up the motive more than the actual prosecutor did by using those terms. Like, I think, and I think the defendant liked hearing that. I think he liked hearing all this kind of things. It's basically trashing Ariel. So I just thought that was a tricky move by them. They kept trashing Ariel as being an adulterous woman. So that's a high risk maneuver. I just think it's not going to pay off. So there's only about 25 pounds difference between Ariel and Gerhardt. So really, you got so much more strength than her. You would have been at least double her strength. On top of that, weight difference. Yeah, Sparky down here struck some people who believe he's not guilty. Well, I don't. Either they sincerely believe that, or they haven't seen the case enough, or maybe some of them are trolls as well. Julie Plank, you're saying she wouldn't even admit she hit him at all or even tried to defend herself until she was asked by the prosecutor. Okay, well, she didn't come across the best, but she's definitely got some injuries, okay? I think her testimony is way, way more credible than his. I don't take it that everything she said was completely accurate and truthful. I'm not saying that at all. So I think the jury's going to be back this afternoon. Let's see, they're going to have some lunch ordered. They're going to sit around, maybe not talk about the case so much while they're eating, and then they're going to start going into discussions. So I see them coming back between 2.5, 3.5 hours. They're going to come back today, though. I'd be surprised, really surprised, if they want to come back tomorrow. Yeah. Yeah. Keep that in mind. Yeah, there's people that try to stir up naysaying commentary because that helps their channel. I mean, there's somebody here that's mentioned over and over again on this chat. And it's really distracting from our own conversation because they have an opinion that this guy's not guilty. Well, look what attention they're getting from this. So really, if they're so credible about the case, then go watch them, and you don't need to keep commenting and focusing on that person's opinion. It's one person's opinion, okay? Are they a criminal law expert? No. So if you think that is a worthy source of information, then go ahead, follow them and stick with them. So I'm not here to build up subs or likes or hearts or anything like that. I'm just here to talk about the truth as I see it as an experienced trial attorney in criminal law cases. So that's where it's at. So I'll come back here, folks, and when I hear that the jury's back, so I'll try to do live coverage on that here today. They will have something on the record to dismiss them if they're not done deliberating today. So anyway, y'all take care. Hopefully I'll be back here in a couple hours. before their 5 o'clock mark hits. I think the judge said 5 o'clock. So, all right, take care. See you soon.